All right, welcome to the video lecture for Chapter 10. This chapter deals with the exclusionary rule and identification procedure. So just a general reminder that exclusionary rule makes evidence inadmissible at trial if the defendant's constitutional rights were violated. Now, a lot of the violations occur under the Fourth Amendment, but it is possible that an in-court identification or pretrial identification could violate the defendant's Fourth, Fifth, Sixth, or 14th Amendment rights. So it does expand beyond that. So there are three basic types of identification procedures. There is a lineup. This is a line of persons who all look similar to the person who is believed to have perpetrated the crime, and the witness is asked to choose the person that they saw. Can they identify the person who committed the crime? Show-ups are one-on-one presentations of a suspect to a victim or witness for identification procedure. So one at a time, people come in until or unless the witness can, or if the witness can identify the perpetrator. A photo array is a presentation of a variety of photographs to identify the perpetrator. So the Sixth Amendment right to counsel can apply here if the individual has been charged with the crime, then the Sixth Amendment right to counsel applies to pretrial identifications because it is a critical stage in the proceeding. Because essentially, a critical stage is any point in the process where the case could be dismissed. So pretrial identifications, if the person is not identified as the suspect, or no one is identified as the person, then the charges could be dismissed. So as long as as long as the initiation of adversarial proceedings have begun, whether that occurs through a formal charge, through an indictment, through an information arraignment, or preliminary hearing, lawyers are required. Now, another way to think about what's a critical stage is whether at the trial itself there is any substitute for having an attorney present at that point in time, a pretrial confrontation, something along those lines. Post-indictment lineups are critical stages, again, so after someone's been charged, it's a critical stage. If a defendant has not yet been formally charged, though, they are not entitled to have an attorney present at the identification process. So here, a person's Sixth Amendment right to counsel could be violated. If they have been indicted and they appear without the help of their attorney, then their Sixth Amendment rights could be violated. But an identification can still be excluded if it violates due process under the Fifth or 14th Amendment. And these are the clauses that ensure defendants get a fair trial. So if a identification procedure is unnecessarily suggestive or in other way conducive or irreparable to a mistaken identity, the defendant's Fifth Amendment or 14th Amendment rights have been violated. 14th Amendment if it's in a state court, Fifth Amendment if it's in a federal court. So more than one way to violate a suspect's constitutional rights during this identification procedure, which is, again, another reason why it's just so vital that officers are aware of the process and procedures put in place by their department and their agencies, and they follow them to the T every single time. All right, so the impact for when a pretrial identification goes wrong, for when it violates the suspect's rights, and how does that matter for when we actually get into the courtroom? So it is possible for an out-of-court identification to be inadmissible in a violation of the rights, but the same identification can be made at trial and be admissible. On the other hand, if the in-court identification is so this is the language of the courts, is so influenced by the illegal out-of-court identification as to be a product of it, then the in-court identification is also inadmissible. And it's really vital to a prosecutor's case that they be able to correctly identify a witness in the courtroom. So if the out-of-court identification that violated the defendant's rights is so suggestive, is so influenced that an in-court statement cannot, in-court identification statement cannot be made, that is problematic. So now, under this standard, we evaluate whether a pretrial identification violates the suspect's rights by a totality of the circumstances standard. We look at everything put together to make this decision. So it is possible, let me rephrase this, only based on the totality of circumstances, a pretrial identification that is unnecessarily suggestive would violate the rights. So it is possible for one to be suggestive of who the suspect is and still be admissible. So it needs to be unnecessarily suggestive. Officers did not need to engage in the identification process this way to have gotten a positive identification. And the fact that they did so violates the suspect's rights. Okay? A little tricky. If you find this language very repetitive and confusing, please reach out and let me know. I'm happy to work through these concepts with you. So, types of identification procedures that are suggestive that can be problematic depend on the size of the lineup of the array. So, more often than not, the smaller ones can be more problematic. If witnesses are allowed to collaborate and identify together, that's problematic. And how officers instruct the witnesses can be unnecessarily suggestive. Composition of the lineup or array, these individuals need to look similar. If the suspect was described as extremely tall by the victim or the witness, and they put one really tall person in there with a bunch of short people, that's a problem with the composition. If the person's pretty tall, then everyone in there probably needs to be tall in order for it to be meet the constitutional standard here. The different appearance of the accused, and there are some other ones that are suggestive, but that only deal with photo arrays. Now, photo arrays are just a much less common method of pretrial identification compared to lineups and show-ups. So then the next few ones, again, a lineup or an array, a single photo, too small, one person or only two people are probably going to get flagged as highly suggestive unless there is an emergency or exigent circumstances. Witnesses collaborating increases the rate of misidentification. Everyone should be kept apart and they can each review one at a time. Officers, the most common police instruction that becomes highly suggestive is when the officer says that the photo array, the lineup, the show up that they are going to view includes a defendant who is already in custody, because the witness will be more likely to pick somebody than no one in that circumstance. Composing, asking them to dress a certain way, different races, or such a dissimilar appearance, like my example of a really tall defendant was placed with very short individuals. This is a direct quote from a court. So again, other ones that are just to photo arrays would be the quality or type of the photograph, the content on or around the photograph, and alteration or disguise of photographs. So now back to what courts are doing when they get when a pretrial identification is challenged. Courts are looking at the totality of the circumstance. That's what really matters. But there's also something else that comes into play, and that is the reliability of the identification. So things that indicate reliability, indicia of reliability, come from the Biggers case in your book. And these things are the witness's opportunity to view the suspect at the crime scene. So a longer period of time that they see it, the more likely they are to remember it, the more reliable it is. The witness's degree of attention that they paid at the time. You know, if it was in the middle of a huge car accident and there's tons of noise in cars and there's people screaming and there's sirens, the witness's attention is going to be divided by all of the chaos versus a crime that occurs on a quiet street during daylight, where the witness is going to be able to recognize the disturbance and pay more attention to it. Accuracy of their prior description before the identification, the level of certainty demonstrated by the witness at the confrontation, and the length of time between the crime and confrontation. Generally, we would like to do these as close as possible, just with the way that memories deteriorate. Again, these are essentially the same factors that we just looked through. And we just talked through these. So I'm going to move forward a couple slides to eyewitness evidence, a guide for law enforcement. So this comes from the Department of Justice. And in general, these are some suggestions that the Department of Justice has made to law enforcement for ways that they can make eyewitness identifications as reliable as possible. Their procedure should contain a minimum of 5 fillers, non-suspects who fit the description of the perpetrator. So in other words, there should be at least 6 people in lineups, in show-ups, in photo arrays, because at least 5 people who are not the suspect should be in the procedure. Instructions to the witness should be based on the Department of Justice's guide, and they should be given prior to viewing it to make sure that the witness understands the process and the instructions, and that the purpose of an identification procedure is not only to identify the perpetrator, but to exculpate the 5 filler individuals that are there or more. Additionally, individual photographs should be placed in random order. They should be viewed at one time. Witnesses should not be given pressure. They should not have, like, you have 1 minute per photograph or something like that. And they should be told that they can take as much time as needed before and make a decision on each photograph before moving to the next one. When presenting a simultaneous live lineup, the investigators should instruct everyone not to suggest in any way the position or identity of the suspect in the lineup, because if they are all leaning away, if they're all tilting their body towards one individual, that as a witness is suggestive to who the perpetrator or the suspect is. So none of those things should be done. Again, if there is a little bit of suggestiveness, the identification could still make it in, but it is going to be challenged, and there is going to be a series of motions going back and forth to determine whether or not this identification violates the suspect's constitutional rights or not. All right, so this is the end of the slides for chapter 10, a little bit shorter than some of the other chapters this semester. If you have any thoughts or questions, if you're struggling with any of the language or concepts, definitely reach out and let me know.